You sue your doctor claiming that he was careless and that his carelessness caused you harm and injury. Your case goes all the way to trial. Why? Because the defense refuses to take responsibility for their actions. At trial, we put on a medical expert to support our case. The defense opposes and puts in their own medical expert. If both of these medical experts have similar credentials, who's the jury going to believe? You want to know the answer? Come join me on this walk around the neighborhood as I share the answer with you. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so now we have two opposing medical experts, both with similar credentials. They've both gone to good medical schools. They've both done their training at well-respected places. And now they've been in practice, let's say 20 years equally. And they both have publications to their names. And they both specialize in the same type of medicine that we're talking about here. So now one expert gets up to testify, and he's very compelling. Why is he compelling? Because his story makes sense. The medicine makes sense. What he's saying makes sense. Now the defense expert gets up to testify. What he's saying makes sense. What he's telling you makes sense. The medicine makes sense. And now, what does the jury think? How is the jury going to be able to understand which expert is more believable? Here's something you should know in case you don't already. Credibility is a key thing in any trial. Why is that? Because the jury has to decide who is more believable. Is the injured patient more believable? Is one expert more believable than another? Is one witness more believable than another? The jury has to assess and decide for themselves which of these people who are testifying and which evidence is more believable. Now, something else you may not know. The person who is bringing the lawsuit, known as the plaintiff, does not have to show with 100% certainty that what he or she is claiming is correct. Did you know that? We don't have to show with absolute certainty. We don't have to show beyond a reasonable doubt that what we are claiming is true. Instead, we only have to show that we are slightly, just slightly, more likely right than wrong. And when we do that, then we are entitled to a verdict in our favor. That's a remarkable difference. So we tell the jury during jury selection, listen, you guys don't have to sit here for days and weeks trying to make 100% certain or absolutely sure that what we are saying is true. Instead, if we are able to show that we are only slightly more likely right than wrong than what we are claiming is true, now we are entitled to a verdict in our favor. So let's get back to the question I asked. If now we have two competing medical experts and they both have good credentials, how does the jury know who to believe, especially when they are coming in with opposing medical views? And you know what? That is a challenge. The jury has to assess who they like better. The jury has to assess who is more credible, who is more believable, which story makes more sense from a common sense standpoint. The jury must determine for themselves who is more believable. So how do they determine who is believable? So let me take you back in time to when you were in grade school. If somebody you just met made a promise and didn't live up to that promise, did you trust them afterwards? The answer is no. But again, you don't get a chance to talk to these people. You only get to form impressions based upon the questions they are asked and the answers that they give. So how do you know, in fact, if someone is trustworthy? Well, if you're sitting there and watching this, whether you're in the back of the courtroom or you are on the jury, now it becomes a question of using your life experience, of determining for yourselves whether or not somebody is trustworthy. Is what they are saying credible? And you have to use your own life's experience to make that assessment. And now when you're in the jury room evaluating whether or not these witnesses are credible, whether they are believable, now you have to come to a consensus with everybody else in the room to determine whether or not you actually believe witness number one, the doctor who came in on behalf of the injured patient, or doctor number two, the one who came in on behalf of the doctor who is being sued. There's no easy standard upon which to decide whether or not one witness is more believable than another. What happens if they are both equally believable? Well, now the patient has a big problem, because if they are both equally believable, there's a problem. It means that the attorney has not been able to show you that they are slightly more likely right than wrong than what they are claiming is true. The judge will tell the jury at the end of the case that if they come up with a solution that's 50-50, guess what? Then you have to give a verdict in favor of the doctor who is being sued. But if you find that the injured patient can show just slightly more than 50%, now you are entitled to give that patient a verdict in his or her favor. So why do I share this information with you? I share it with you because this comes up in every single trial, because credibility is so crucial in every single case. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit, and are thinking of doing so but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.